Well, it's my pleasure to introduce the third session, which is on balancing the scale, public welfare and policy making. And there are three speakers forming this session. The first, Kate Tokeley, the author of the text on consumer law, will be talking on the topic of consumer law and paternalism. So in this morning's keynote address, we were told of the sort of increasing salience of the consumer perspective, and that will be sort of directly and squarely addressed in that talk, looking at paternalism and the underlying issue of what counts as a consumer preference. Then the third paper in the session is that of Paul Scott, who's worked as a practitioner and academic in the area of competition law, and he'll be talking directly to the adequacies of generic competition law for dealing with particular networked and particular industries that are often seen to have special needs that takes them outside of what can be catered to by generic competition law policy. And the central paper really combines some of the aspects of the two papers either side of it. Dr. Mark Bennett, who's just finished his doctorate from Toronto, will be looking at some of the ways in which consumer preferences and consumer issues can be factored into a regulatory approach in industries such as in the electricity industry. So as everyone needs the time allotted for their presentations and questions, I'll end there and turn over to the speakers. Kate.
Thank you. Hi everyone. Okay, so New Zealand consumers have some problems that we can probably only blame on ourselves, and we're not the only country that's got these problems. In fact, maybe they're not problems at all, maybe they're just choices. Every day as consumers we make choices about the goods and services we buy and on what terms, and some would argue that we're making some pretty poor choices. We choose, some of us, to eat too much of the wrong food. We're the third fattest nation in the developed world. Many of us don't save enough for our retirement. Some of us choose to spend money on gambling. We choose to purchase a large amount of alcohol. Many of us engage in sometimes dangerous adventure activities. Many of us make poor choices about what to borrow and on what terms. 1 in 5 of us are smokers, and 50% of those people will probably die from their habit, at least 50%. And most recently in the news, many of us fry ourselves on sunbeds. They're just some examples. And the question that my part of the project has been dealing with is whether the law should intervene to protect consumers from themselves. And often a debate of this kind can revert to an exchange of broad, unexamined assertions. So someone opposed to a law will just say it's too paternalistic, it's an example of the nanny state. And on the other side, someone in favour of the law may just refer to some vague assertion that it's needed for consumer protection. So the aim of my project was to try and develop a more detailed framework for decision making and encourage a more informed, structured debate on the topic. So the first job was to define what I mean by legal paternalism. And I'm saying that that is any law that has the goal of changing consumer behaviour in order to increase consumer welfare. Now, the law will do that by restricting the consumer's liberty. And the restriction can range from an extreme restriction to a quite minor one. So and it's a continuum. So at the extreme end, you've got what's often called hard paternalism. And that is where the law is trying to coerce consumers to behave in a certain way. So it's trying to stop us buying dangerous goods by banning them. That's the most obvious example of hard paternalism. So bans on untested medical drugs, flammable nighties, that's hard paternalism. Or trying to stop us agree to unfair terms, that's hard paternalism. At the other end of the spectrum is what's often called soft paternalism, where the law is trying to nudge us towards behaving in a certain way rather than coercing us. So then the consumer retains the freedom to make the bad choice, but it's just more cost, hassle, pressure. So, for example, if you remove the GST from fruit and vegetables, that's aiming to encourage us to eat more healthily, but we still retain the ability to make the poor choice and eat only junk food. Other examples are opt-out retirement schemes, plain packaging on tobacco, etc. Now, when we're trying to assess whether a law is paternalistic or not, it's of central importance to focus on the goal of that law. So, say, for example, in the area of consumer information, we have some non-paternalistic laws like the Fair Trading Act, where the aim is to ensure consumers receive accurate, non-misleading information. Now, that's not paternalistic because the aim is simply to say, consumers, we want you to have all the accurate information so you can make the decision that you think is in your best interests. Just do it with your eyes wide open. Now, another example of an information law that is paternalistic would be, say, putting graphic images of disease on a cigarette packet. Now, that's not just saying, hey, eyes wide open, just want you to know what you're letting yourself in for, but do what you want. No, the aim is to stop you smoking. The aim is to change your behaviour to match what the government thinks is in your best interests. So that it does have elements of paternalism in it. The other thing to not get confused by is, really clearly assessing the goal. So some would say the goal of smoking legislation, for example, isn't to protect you from yourself, is to protect you from harming others, because you're going to increase the costs of the public health system, and that's all we're interested in. But you have to be really honest and clear about whether that really is the goal, because tax at the moment covers the costs of the public health system, and we're still regulating tobacco. So it is about paternalism. It's also about protecting the consumer from themselves, from the harm they're causing themselves. And of course, it's possible to have those two goals coexisting, a non-paternalistic one and a paternalistic one, in the same legislation. So the current theories on paternalism, okay, there's traditional paternalism. We accept happy that the government sometimes knows best. Then there's anti-paternalism, which is against any form of paternalistic law. And the idea behind that is, look, consumers are rational, they're capable of making their own decisions, and they can work out what's in their own interests, and the government should keep out of that. And also behind the idea of anti-paternalism is the ideas of liberty associated with John Stuart Mill, the idea that unless you're harming other people, it's none of the law's business what we're doing to ourselves. And then in more recent times, there's been lots of findings in the area of behavioural economics that you're probably all familiar with, that we're actually not that rational, and we're not good as consumers at making decisions that appear to be maximising our welfare. We lack self-control, we're bad at processing information, we're impulsive, we misperceive costs and benefits, we have a present-day bias, we have a status quo bias, and this has led to what's called Libertarian Paternalism, a strand of thinking which says, okay, we're making poor decisions, so it should be legitimate for the law to nudge us towards making better decisions. So they would say soft paternalism nudges should be fine, and they're just encouraging us to do what we could do if we were perfect human beings, so nudging us towards our true, deep preferences as consumers. And the last one I'll mention briefly is asymmetric paternalism, which just says it's okay to intervene if you are giving a large benefit to irrational consumers and there's little or no harm to the rational consumer. So going back to that idea, consumers act in ways that appear irrational. That appears to be what's happening. We do things that aren't in our best interests. So that just leads us to think, well, so what? We're making mistakes. the anti-paternalist brigade have not taken those new findings and thought, oh, we were wrong about the rational consumer, fine, the law should help us to make better decisions. No, they're still hugely concerned about paternalistic laws, and their concerns and objections to paternalism are both to do with freedom. They're both ideas about freedom. Their first argument is essentially that freedom is still the safest way of achieving maximum consumer welfare. So they say, well, look, we're irrational consumers because we're humans, but the government's made up of humans too. They're irrational as well. Irrational government, irrational consumers. Still, just let us make our own decisions. And then also tied up in this idea that we should be able to make our own decisions is that consumers are actually often choosing between two sets of preferences. So we prefer to save for our retirement, but we also prefer to spend big now. So we've got two preferences competing with each other. And who's to say which is the most irrational of those two preferences? And also, consumers are not a homogenous group, so our preferences are all different. One smoker may say, I would prefer, and my choice is the pleasure of smoking is worth it to me, even if I lose some years of life. Another smoker might say, I'm desperate to give up, I'd like all the help I can get. And also preferences are not even stable within the individual. So in the morning you want to lose weight and be healthy and live a long life. In the evening your preference is for 3 desserts after dinner. Same person, different preferences, constantly changing. Now the second idea about freedom that freedom has intrinsic value. Now that's quite different from the first argument, because that says, okay, even if you can prove that we are making decisions that decrease our welfare, it still shouldn't be for the government to come in and try and help us. Figuring it out ourselves is part of being human, making mistakes is part of being human. Even if you can prove that we're making bad mistakes, it shouldn't be an area that the government is involved in. So, okay, that's the objections. And, yeah, then I was asking whether the existing theories on paternalism are actually helpful to policymakers in deciding which way to go. And they're probably not that helpful in that they try to come up with a unifying theory. If you go back to the 4 that I had, they're either saying, yep, paternalism's good, no, it's bad, or it's good if it's only soft. Now, complete anti-paternalism is probably not desirable. We already have widely accepted laws that are paternalistic in nature. We don't have heroin on the supermarket shelves. We don't have no age restrictions on tobacco. We don't have no airline safety regulations, so you can just go and choose your own safety and price combination that suits your level of risk aversion. We don't have a choice as to saying, no, I don't want a statutory guarantee about the quality of goods. They're all paternalistic laws that are largely accepted in our society. On the other hand, uncritical paternalism is also not sustainable. If we're going to restrict liberty, we should be proceeding with caution. So the challenge is to develop that middle ground. And the idea that the middle ground is libertarian paternalism will just only do soft stuff isn't really a complete answer, because it can't account for when it might be okay to enact hard paternalism, of which we do a lot anyway. It also has no mechanism in the theory for excluding government intervention for all consumer errors. We can always nudge you to better behaviour. You're wearing high-heeled shoes and it's making your feet sore, let's nudge you to not wear them. There's no mechanism to sort of distinguish between, pushes that are okay and that are not. So suppose the state wanted to enact laws that would remove a consumer's freedom to buy chocolate or ugly clothes or fly in a hot air balloon or climb Mount Everest or purchase an expensive kitchen renovation which is guaranteed to not increase your happiness at all. How's the policymaker to distinguish between arguably legitimate interventions and those that are illegitimate. It can't be that we intervene whenever the government thinks we're making a mistake. Okay, so here I've come up with a list of factors that I think are relevant to making that kind of decision, that acknowledge the complexity of the issue. I'm not trying to advocate an exact point at which it's okay to intervene. Different people will disagree. Yeah, people will all disagree about the exact point at which they think intervention is justifiable. All I'm saying is that the debate should consider these factors, and more importantly, that it should be understood why these factors matter. Now, they matter because they all provide a response to the objections to paternalism. So those two objections about freedom, to argue against them, you're going to need to show that you've got these kind of factors. So the things that you need to consider, you look at the consumer problem, you have to work out the magnitude of potential consumer harm, the probability of that harm, the irreversibility of that harm, the degree to which addiction is affecting consumer choice, the degree to which consumers want to be protected, the degree to which consumers are dealing with complex, large quantities of information, the degree to which the problem is affecting children or young adults or other potentially disadvantaged groups, the degree to which there are additional non-paternalistic reasons for enacting the law, in other words, the behaviour is hurting other people as well, and the probability that a non-legal response could sort this problem out. So some consumer problems could score quite highly on a lot of those factors. For example, airline safety, maybe leaky buildings. You've got high degrees of harm, lots of information for consumers to deal with, and consumers probably happy to be relieved of the burden of the freedom to make their own choice. Other consumer problems, times when we're making mistakes, will rate lowly on all of these factors. So, yeah, you buy your high heel shoes that are bad for your feet. It's a consumer mistake. It might be irrational in some people's eyes, but the harm isn't very high. You're not addicted. You're not hurting anyone else. There's no informational problems. So that's where the two arguments about freedom actually work. Yeah, it's better to let you make your own decisions, and there's intrinsic value in freedom. The more harm you've got, the bigger the more you get factors on these factors, higher scores, it becomes harder to sustain those arguments about freedom. I mean, if you have an extremely dangerous drug, it's harder to say that the consumers are making the best decision about what's in their best interests. It's just harder to argue that there's an intrinsic value in making that kind of mistake when the fallout's so large. You may still be able to make it, but you've got a better argument in that situation than with the high heel shoes, for example. The middling areas are, of course, where the debate is possibly most lively, because you might have high in one area and not another. So, say, unfair terms prohibition, you say, look, you're agreeing to unfair terms and standard form contracts. It's not serious harm, there's no addiction, but consumers are possibly happy to be protected in that way. So that's, a call that the policymaker has to make. And the other thing to mention is if you're low on the factor of consumers wanting to be protected, so if consumers don't want the help, they don't want their freedom intervened with, you're going to have to point to a very high score on one of the other factors, certainly to do something that's a hard paternalism. And my last slide is just to say that my project focused on this first part of a two-stage process, really. The first question you should always ask is it legitimate to restrict consumer freedom? And I've provided a framework for making that decision. Of course, the second question is then, if you get a yes on it's legitimate, then you have to decide whether the proposed intervention is actually going to work. Is it going to be effective to change consumer behaviour? And is it possibly going to have unintended negative consequences that need to be taken into account? So, in one of the states in America, they taxed beer really high tax rate, yes, it was effective. It decreased the rate of beer consumption, but there was a corresponding increase in the rate of cannabis. So it's had an unintended negative consequence, and that's something to be weighed into the mix. But it is, it's very important to ask that question first before you skip on to the second question. It has to be legitimate before you start worrying about designing something that's going to work. There's lots of things you could do that are hard paternalism that will reduce consumer error, but they're not necessarily legitimate interventions. So that's just a quick summary of my part of the project. Thank you.
Dr. Mark Bennett, but just to clarify, we'll take questions after, so we'll have all three presentations first and then take questions after the three.
All right, so from one big question to another, and like Kate, I'll take you on quite a whirlwind tour through my and Joel's project, Public Participation in Regulatory Decision Making. Now, we produced, I think I counted it up, around 130 pages over the two books, so if you are interested in delving more deeply into these questions, you can see how we thought about it by looking at the books. But the basic questions that me and Joel tried to answer were: what role should ordinary members of the public, consumers, citizens, think of them how you will, play in the what role should they play in the making of particular regulatory decisions? Yeah. And echoing one of the very good observations that Professor Haynes set forward in her lecture, there are no general prescriptions. That was one of the key things that we thought needed to be made clear. What there are reasons for and against increased public participation in regulatory decision making that may or may not apply in any particular case. There are mechanisms that respond to those reasons, and then when you're looking at the particular area that you are trying to figure out should there be more participation in, you will have to sort of calibrate those reasons to see whether they apply, and then think about what kind of mechanisms best respond to those reasons in the particular area. Okay, so what I'll do is just briefly go through the reasons that we identified stemming from the participation literature, the possible mechanisms that you might use to get increased public participation in regulatory decision making, and then I'll just briefly walk you through my analysis applying those reasons to a particular area, electricity. Okay, so reasons for participation, they all seem to add up to an idea of regulatory legitimacy, and these include democratic values, the idea that an election every 3 years and the current ordinary processes of government and legislation aren't enough. People need a greater degree of influence and participation in decisions that affect them. Increasing the regulator's accountability, providing transparency, and getting a sense of what the reasons for the decision were so that you can check that the decision maker is doing things properly. Educational benefits, both for the person participating, who gets a sense of what are the trade-offs involved, what are the levers that are being pulled, what are the values and interests that are part of this decision, but also on the part of the decision maker, who can benefit from the public's participation in getting information, preferences, values to inform their decisions. This seems to add up, according to many commentators, to better regulatory outcomes, specified in terms of whatever your ultimate outcome of regulation is, or in terms of the particular regulatory objective set forward in the legislation. Getting more information, more perspectives, more values, it said, is going to aid you getting the best outcomes or decisions. And then also there's an idea that there's going to be increased compliance. If people understand the process, can see the trade-offs involved, they might feel better about complying with the final outcomes. Okay, the reasons against participation that are set out in the literature, one reason is countering the democratic. Reason 4 is that it's just unnecessary. We do have enough democratic legitimacy just through ordinary governmental processes. Even if we've delegated decision-making roles to relatively independent and unelected decision makers, there's still a democratic link of legitimacy, so this is just unnecessary from a democratic values perspective. Obviously it's time-consuming and costly engaging further with ordinary citizens about what your decision should be. Another big reason which we've talked about already is the idea of this is a technocratic decision. It's a fairly simple means-end decision that a scientist or an economist can crunch the numbers, crunch the data, the information, and come up with a good decision in the end. Whether or not that's the case, it's certainly not a decision that an ordinary member of the public has any understanding of and any ability to contribute to in a useful way, because it's just such a complex decision. Okay, so that's technocracy. Another thing that people say is citizens don't like participating, so why create this expectation on them doing so? And if they generally don't like participating, then by setting up a participatory process additional to the existing ones, you're just letting in further opportunities for those who are interested, especially interested, to influence the decision maker towards the decision they want to have. Okay, so if you've decided that, well, I still do want to engage in some further participation from the general public, obviously you can have public hearings and submissions. That's the basic way that we do things at the moment. Our current governmental and legislative processes rely heavily on these things, select committees, governmental inquiries and so on. Less traditional means of getting citizens and consumers to participate are focus groups, public opinion surveys, citizen panels, so accessing the knowledge, preferences, values of the consumers. An even less used form of participation, but which has nonetheless been used in some areas, is citizens' juries or deliberative polling. And this is a structure, we describe it in much more detail in the paper, where you get a group of citizens together, you actually give them further information by experts, analysts, provide an analysis, and then the participants can deliberate and ask further questions and come up with, well, this is what we think the decision should be, and that can be publicised to the wider public. Okay, the other two mechanisms that identified by looking at the electricity industry in particular in my research into this were consumer challenge groups. These are expert bodies within a regulator that provide a citizen's or consumer's perspective on particular regulatory decisions so as to challenge the regulator's own thinking or the regulated industry representatives, business representatives' thinking. Usually 6 to 8 people with a consumer expertise or focus and an expertise in regulation and the particular industry, providing advice in that way. And then also you've got consumer advocacy bodies. So these are bodies sitting outside of the regulator which are trying to put across the consumer's interest in, and again this is primarily in public hearings or submissions. So it's a way in which you can represent the consumer interest rather than just ordinary people participating. You represent what you think the general consumer interest would be, or represent a number of different consumer interests and highlight that to the regulator to help the regulator make their decision. Okay, so those are the mechanisms. In terms of applying this to a particular area, I chose electricity. Again, I'm one of the people who doesn't know anything about this in particular, but I figured out that in the electricity industry you've got regulatory concerns around economic questions about efficiency and competition, questions of natural monopoly and how to regulate that. You've got more technical questions of stability of supply, how much do we want to pay to ensure that our supply is stable and that it continues, how do you recoup those costs. There are social issues about disconnection, universal access. There are general consumer issues about information provision on tariffs, billing, and also we've got quite a prominent campaign at the moment about switching between electricity retailers. So those are the issues involved in electricity. So if those are the issues, and here are the kinds of decisions that we need to take, we need decisions about the general framework of the industry. What is its structure going to be? Are you going to divide, separate out the industry into transmission, distribution, generation, retail? Are you going to allow companies to come together? Who's going to own it? What kind of competition regulation or price quality regulation are you going to put in place? So these are the general framework questions, and usually these are set out in legislation. So the government is taking those decisions. And then you've got more specific decisions within that framework. So the regulators are making particular determinations or rulings within the framework, applying the framework. For example, Commerce Commission price quality path decisions. Okay, so that's what's happening in a nutshell in electricity. What kind of participation did I identify? Well, again, public hearings and submissions seem to be the main way in which industry and also consumer groups participate. Mostly industries participating, although there is some participation by consumer groups, either major consumer groups or else residential domestic consumer groups like Consumer New Zealand or Grey Power or the Domestic Energy Users Network. Okay, but it seems to be dominated both in volume and in terms of the kind of documents that are put forward and the analysis behind them, analysis from consultants, economists, etc., by industry. Now, the other participation mechanism I found was in the Electricity Authority. You've got a retail advisory group advising the authority on retail market questions, and they include a couple of consumer representatives or experts. So that's how it sits at the moment. Now, just thinking about applying those reasons, everyone will have a different way of applying those reasons, or can thinks that those reasons do or not apply in general, or has a different way of understanding how they apply in particular in this case. But one thing that I found doing the research is in Australia they've got a very different way of seeing it, it seems, than we do things in New Zealand. So a 2005 KPMG report on consumer advocacy picks up on two of those main reasons that I put out initially in particular. It talks about the essential nature of the service, but then it moves on to the fact that there are a few large and sophisticated sellers in the relevant market and many buyers who are diffuse, unorganised, and for whom energy is a relatively minor cost. Again, that's picking up on the idea of citizens or consumers, the ordinary public, aren't interested in participating. They don't see the concrete benefits, whereas the industry clearly does see the benefits of getting the decisions made more to their favour and therefore trying to influence that process. The other thing, so that's special interest domination. The other thing is within the current process, KPMG said, well, this is a highly complex technical industry, and this limits the ability not only of ordinary citizens but those who would try and represent the consumer interest. Even groups who are doing this on a relatively day-to-day basis are organised, standing groups thinking about these issues. They just can't, they don't have the capacity to contribute to these debates properly because they can't hire the consultants, the economists, the lawyers to properly inform them and provide that research. Okay, and this is not just, this is quite a pervasive theme, and I'll put up these PowerPoints just to show how pervasive it is. The Australian Energy Regulator and the Australian Competition and Consumer Commission in 2013 put forward a submission on consumer advocacy. Again, they're talking about the complex nature of the issues, preventing consumers from being able to participate. And as a consequence of that, energy business positions and perspectives getting far more airplay and having more influence, presumably, than they would otherwise have if they were challenged by a consumer interest advocate. Okay, so that's picking up very clearly on two of those reasons. Now, we can debate whether special interest domination and technical complexity means that we do need to have additional participation in this area, but it's very clear in Australia that that is the view. Okay, so the Australian approach to respond to that in terms of what kind of mechanisms do they use to get around these problems is they fight fire with fire. They take the reasons against further participation And they say, well, the way to get around those problems is to get more participation of those interests that aren't naturally going to participate, and of those people who don't have the resources to get a technical handle on the area. And so what they do is, there is a vibrant ecosystem of consumer advocacy organisation based out of law schools and funded by state and local governments, general NGOs, councils of social services. They play a part in advocating what they see as the consumer interest in the submission, public hearings and submission mechanisms that exist. Those, again, are the predominant mechanisms, but they supplement those mechanisms to get around some of those problems that were identified. In addition to that, there's funding granted by the government effectively, or subsidised by industry, that allows for the funding of these groups. So where it's necessary to build capacity, to hire economists or other kinds of consultants, regulatory consultants, that funding is available, and so $2 million every year is doled out to around 40 to 50 projects to aid in consumer advocacy in the energy area, and that is seen as a highly effective way of getting the consumer interest involved, and the advocacy is seen as really high quality. It also reflects the diversity of consumer interest, because it's not only residential, it's also major users can use this money as well. So again, supplementing those general ordinary mechanisms of public hearing and submission with things that give the consumer interest the ability to be effective in those mechanisms as it's represented by these groups. Okay, the other two things I want to mention is there are a couple of new developments more recently. Within the Australian Electricity Regulator, they have seen fit, because of those same reasons of technical complexity and imbalance in the views between consumers and industry, they have seen fit to put in place a consumer challenge panel, the mechanism that I referred to on the mechanism slide, and that is going to try and provide an account of what the consumer interest is if the regulator is not properly attending to it in the view of the consumer challenge panel. Okay, so it's going to be a panel of experts in regulation and energy, and it will advise in terms of particular determinations whether the regulator is dropping the ball in terms of its statutory objectives. Okay, so that's another model within the regulator. The other thing that's happening right now, and there's consultation documents going around as we speak, is the proposal for a national energy consumer advocacy body. Again, it's almost, I think a lot of it's almost plagiarised from one of the previous slides, although it's a different submission or a different proposal. The problem of complexity, technical complexity, the imbalance in participation, what that requires is a national advocacy body across a wide range, basically the whole of energy policy in Australia, local, state and national, and performing a whole range of functions. Consumer representation, advocacy, capacity building of those other groups that already exist, the vibrant ecosystem, disseminating information to consumers, policy review, and comment at the national level. So an overarching consumer interest group. And again, they're saying, well, sure that there's different consumer interests, but it's part of our role to identify what the different consumer interests are and put that on the table for the regulator to consider. Okay, so I guess my question is, why not here? Why do those reasons not apply? And if they do apply, why shouldn't we look across the Tasman, but not only across the Tasman, because a number of these models are taken from the UK. So the Consumer Challenge Group concept comes from the UK energy regulator. and the idea of peak consumer advocacy comes from the UK Consumer Focus, or now it's called the Regulated Industries Unit, so an overarching consumer advocacy body in regulated industries. And this is not just in energy, it's also across telecommunications as well. A lot of this model, these models of getting the consumer voice better represented, are also found in telecommunications in Australia and elsewhere. So that's kind of my question. Do the reasons come out differently in New Zealand? Have the Australians got things wrong and they've misjudged the reasons and they've got too much participation, or misdirected or misjudged participation? But I guess the point of the whole project was to get us thinking in these terms, or at least offer that as a framework. Perhaps there's better frameworks, but at least if we put this on the table, people can challenge us and come to their own conclusions and propose their own ways of looking at things. Okay, so thanks.
There go all my slides. Now, I looked at competition law, which is a form of regulation of market participants. Now, it's distinct from direct regulation, which I mean price control. And it was my conclusion that the Commerce Act was a terribly tip-top piece of legislation. Now, in respect of New Zealand, we're a small market economy characterised by few participants in many markets. Now, despite this, we enacted a general competition law which did not take account of any real special account of our small size. Now, in this, we differed from Canada, which enacted an act the same year. Now, one main difference was that Canada had its own special section on refusals to deal, which is section 75. And the reason was that policymakers in Canada argued that in markets with only a few suppliers, the refusal to supply by one or two major suppliers could have a significant adverse effect on downstream purchases. And since many markets in Canada only had a few or only one supplier, a special legal protection was needed. Now, New Zealand, despite sharing similar market characteristics, did not do this. Rather, it relied on the general monopolisation provision. And another difference, which is to New Zealand's credit, is that we only had one purpose statement, which the courts have interpreted as involving enhancing economic efficiency. Canada has that, but also has a purpose to ensure that small and medium-sized enterprises have an equitable opportunity to participate in the Canadian economy. Now, 75 doesn't have the refusals to deal a competition section to it. The refusal doesn't have to substantially lessen competition or the like. You're liable if the refusal leads to a person being substantially affected in his business due to his inability to obtain adequate supply. Now, this seems to provide protection for inefficient traders. It aims to protect downstream businesses even at the expense of economic efficiency. Conversely, New Zealand courts have made it quite clear in a number of cases that our restrictive trade practices are not designed for the protection of individual competitors. So it was left to our courts to interpret the restrictive trade practice provisions, and certainly the timing was propitious. It was the height of the essential facilities doctrine. Now, with our section 36, it was basically along the lines of other countries with monopolisation provisions, and I argue in the paper it's a statutory encapsulation of the US black letter law in Grinnell. Now, in developing our monopolisation test, we developed what's called the Counterfactual Test, and it's done to ensure a link between market power in using that market power or taking advantage. Now, some link is necessary from the words of the statute, and it represents our first break with US law, as in the States you don't need to have a link with market power. A bad act unconnected with your economic power suffices for monopolisation. So in a case called US and Empire Gas, a firm was held liable for monopolisation for arson. The United Fruit case, United Fruit was held liable for monopolisation for pouring garbage on ships of its rivals. Now, the counterfactual test has come into for severe criticism, and the first criticism is that it doesn't catch enough anti-competitive conduct. Now, I think that criticism is vastly over-exaggerated. Just want to take the facts of one of the great US monopolisation cases, Aspen. The facts there was that a company called Aspen Ski Company owned 3 of the 4 ski mountains in Aspen, Colorado. It had a multi-pass ticket where you could use one ticket to go on 4 mountains, 3 ski co and 1 Aspen Highlands. They stopped this, and Aspen Highlands sued, alleging monopolisation. Goes to the Supreme Court, and it's held to be liable. Now, the same result would operate in New Zealand. Aspen Ski Company used that multi-purpose card in fields where it wasn't the dominant provider, where it was in a competitive market. So that means that the counterfactual test is met. You are acting in a different way than you would be in a competitive market. They would also get pinged under the legitimate business justification because they didn't have one. They firstly said it was inefficient. Well, they used it in markets where they weren't dominant. They said it was slow and cumbersome. Well, the evidence showed it was far quicker than paying for a ticket by credit card. And thirdly, they said they didn't want to be associated with the inferior facilities of Aspen Highlands. Turned out that Aspen Ski Company's ski executives sent their children to Highlands to learn how to ski. Now, the real problems with Section 36 arose, the interpretation, in the Privy Council case of Telecom and Clear. The case, as I'm sure you're aware, involved access by Clear to Telecom's network, and Telecom offered access on the basis of the Bowman-Willig rule or the efficient cross-pricing regime. Now, the problem was that it could involve protecting Telecom's monopoly profits in its access charge. Privy Council upheld the Bowman-Willig rule, and this caused great criticism. And the main criticism was that a price which protected monopoly profits, the fact that that might not breach Section 36, well, that meant Section 36 would be of very little use. Well, I actually like Bowman-Willig. Firstly, I think it protects incentives to innovate. Secondly, if you're going to enter, you have to be equally efficient to enter. It's equivalent to Dick Posner's equally efficient competitor standard. I don't think you should allow inefficient rivals entry in the hope in the long term they're going to help. If you are, you're holding up an umbrella for inefficient entrants. Thirdly, the Bowman-Willig rule's easy to administer. You only have to take account of the monopolist's costs, equivalent to predatory pricing, and you don't need a prior history of dealing to work out the price. You just use the monopolists. The price may well have a monopoly element about it. Well, my argument is, so what? Why else are people trying to enter? They wouldn't be entering if a monopoly price profit wasn't available. Now, it was severely criticised, and one of the most strident criticisms was firstly that it was some Chicago school doctrine and that Chicago school was bad, and secondly it was counter to overseas US, in particular, antitrust law, that you would be pinged in the US for it. Well, this is utter nonsense, and I just want to read Professor Lawrence Sullivan, who is a leading anti-Chicago school scholar in antitrust on pricing by monopolists. Since the public utility approach to the duties of a lawful monopolist does not, as a matter of competition law, limit the monopolists from charging profit-maximising prices, a rule requiring the monopolist to sell to competitors at the next level, which would not foreclose the monopolists from its full monopoly profit, which could be earned at the vertical level it continues to dominate. If only the first level is a natural or lawful monopoly, the monopolist can earn its full monopoly return by setting a profit-maximising price at that level, and it will not breach the antitrust laws. Well, my issue is, if it is not a breach of the antitrust laws in the home of antitrust to charge a monopoly price to an access seeker, why on earth in New Zealand, which was based, this law was based on US antitrust law, why on earth did we rely on antitrust law to regulate these network industries? If we wanted a difference, we should have written a different statute. We should have had a European provision saying something like it will be an abuse or use to charge an unfair price. We didn't, and the law was quite consistent with US competition law. Now we moved on, and much to our credit, the courts developed some individual laws for individual practice. We have for Section 36, a predatory pricing law, which requires recoupment. Granted, we had to rely on the Privy Council and High Court of Australia for that. Now, with refusals to supply, we are different. Australasia seems to have gone on its quite distinct path. Now, in the US, starting with the Colgate Doctrine, a firm, even one with monopoly power, may deal with whomever and on such terms it chooses. So it doesn't never have to supply, but it hardly ever has to. And from a case called Trinco, it only has to supply, firstly, if it's irrational, there's a short-term loss. Secondly, if you're upsetting a previous voluntary relationship. Thirdly, if you're supplying to others, but you won't supply to the plaintiff, well, you can be pinged. And there is no duty at all to share when you are using the product only internally. So if you haven't supplied in the past, you don't have to supply in the future. Now, the situation with Australia is completely different. The great Queensland Wire case would not be decided the same way under the US. Summary judgment would be granted because the defendant had never sold the product to anyone before and it used it internally. Northern Territory's Power, which involved access to an electricity network, they'd never supplied access, they never would have to in the States, but under the counterfactual or QWI test, the High Court of Australia said, well, yes, in such a situation where there were two networks, you would supply, and therefore you've got to under this counterfactual test. So de facto, we have got an essential facilities doctrine. Now, why the difference? Well, firstly, perhaps it is the size of New Zealand and Australia as in Canada. Refusals to supply by one or two major suppliers can have and will have a more deleterious effect than in the US. It's easier to get access in a large country like the US. Secondly, and this is Professor Adair's argument, it may be that preserving and protecting innovation incentives is greater in the US than over here, because in the US, firms which are monopolies have earned that by winning the competitive game. In New Zealand, a lot of monopolists are former privatised public monopolies. Now, I want to turn to the Court of Appeal's decision in Data Tales, Now, unfortunately, when I wrote the chapter, after I'd done a number of drafts, the Court of Appeal case came out, and it does mention a lot of overseas authority, which is quite contrary to previous authority, and I overpraised it. I said it was a tour de force. Well, I take the Keynesian view, and that is Keynes wrote a stellar review of Hayek's The Road to Serfdom. One of his chums criticised him because it was contrary to Keynes's view and general theory, etc. And Keynes said, well, when someone persuades me I'm wrong, I change my mind. What do you do? Now, this is what I've had to do about data tails. One part of the case I'm not concerned with. This is the two-tail situation, which breached the ECPR. I'm fine with that. That's a matter of fact, whether it did or not. I'm concerned with the one-tail pricing, which didn't breach the ECPR. High Court found no liability, and the Court of Appeal did. Now, I find the language quite worrying. At paragraphs 235 to 236, the Court of Appeal firstly comments about the Privy Council and Telecom and Clear, and said that the Privy Council noted Clear could not compete with Telecom, even though the access price complied with the ECPR and preserved monopoly rents. They then went on to say that in its view, it's implicit in the Privy Council's decision that an incumbent can't charge a price above which a rival is unable to compete. And they referred to Professor Ardar's comments that Section 36 is not concerned solely with conduct that totally precludes competition, but also embraces conduct that seriously restricts and deters competition. Well, my problems with this are, firstly, Privy Council's comments were in response to Counsel for Clear, saying that they couldn't compete under the Beaumont-Willig rule. Privy Council said, where's your evidence? And Clear had to say, we don't have any. Secondly, it's inconsistent with the Privy Council quoting Posner that the aim of Section 36 is not to hold an umbrella up against inefficient rivals. Now, thirdly, the comments about deterring conduct are not helpful. The only access price that is not going to deter is one that guarantees the new entrant a profit. So according to the Court of Appeal, you have to guarantee a profit to access seekers, and this is irrespective of how inefficient they are. Now, the Court of Appeal in Telecom Clear came up with its own pricing regime, bit of network costs and return on capital, and said there can be no objection on competition grounds if those costs are recovered. Well, what happens if the new entrant can't afford to pay those costs? Under the strict words of the Court of Appeal, it means the incumbent is charging a price above which a rival would be unable to compete, and it's a breach of Section 36. So the Data Tails Court of Appeal may well have resulted in New Zealand having the equivalent of Section 75 of Canada. You're liable if there's a significant negative effect on downstream purchases and below efficiency. Well, my view in respect of that, that's not antitrust analysis, that's antitrust poetry. Now, it may not matter, as most industries now, although especially telecom and electricity, where you're seeking access, are now regulated. Now, I just want to have a couple of comments on public participation. There doesn't seem to be much in New Zealand's competition law. I want to distinguish that from Australia. I argue in the paper we made a mistake in amending our collective boycotts provision. Well, in New Zealand it was an intellectual argument. I lost, my opponents won, and the section was amended. They tried to do the same in Australia. By the Hilmer inquiry, they recommended an amendment, but small businesses rose up in fury, and it never went through. My next point about Australia is I was reading an Australian competition law blog where the writer in the blog was saying it's going to be fascinating with the election to see what policy changes to the Competition and Consumer Act both parties are going to come up with. Well, I doubt I will ever live in New Zealand where amendments to the restrictive trade practice provisions of the Commerce Act are ever going to be an election issue. My next point is one of my referees was, in Tony Soprano's words, slightly miffled in that I criticised a number of New Zealand judges for being inconsistent in Commerce Act cases. Well, we're not alone. Australian, US judges are equally as inconsistent. Justice McHugh in the High Court of Australia says in the Northern Territories case that we're not going to rely on Section 2 jurisprudence because Section 2 is criminal. Well, it is theoretically, but they've never brought a criminal case under Section 2. But his inconsistency was that he cites US Section 2 law a lot when he introduces recoupment. Michael Kirby does the same thing. Justice Scalia, in a case called Trinco, virtually eliminates the Essential Facilities Doctrine, but in a previous case called Iowa Utilities Board on Telecommunications Act pricing, says that the Essential Facilities Doctrine is a framework for considering the scope of access. Elsewhere, I've criticised our Supreme Court for deprecating economic analysis in the 0867 case. They say it's just got a practical business question. Well, I want to read a cite from Chief Justice Roberts in the Obamacare case. To an economist, perhaps there is no difference between activity and inactivity. Both have measurable economic effects on commerce, but the distinction between doing something and doing nothing would not have been lost on the framers, who were practical statesmen, not metaphysical philosophers. Now, in closing, there are a large number of disputes in competition law in New Zealand. However, they are not ideological. As in the rest of the world, the ideological heat has gone out of competition law. A lot of the disputes are on counterfactual analysis, and the reason is counterfactual analysis is important for mergers, monopolisation, and Section 27 cases. And to be frank, it's not always easy to identify the counterfactual. But when it comes to counterfactuals, I always think of Chairman Mao. And the reason is that Mao Zedong was asked by one of his acolytes, he said, "Do you think world history would have been different in 1963 if Nikita Khrushchev had been assassinated rather than John Fitzgerald Kennedy?" And Mao responds, said, "That's a very important and interesting question. I think that if Khrushchev had been assassinated rather than John F. Kennedy, it's quite easy to work out. I can be quite certain on what would have happened." And his acolyte said, what would have happened? And he said, "We can be certain that Aristotle Onassis would not have married Madame Khrushchev."